Okay, so we want to dig a little deeper into all of this. Joining us today is criminal defense attorney Logan Campbell with Gergen, Hale Campbell Law Firm. So you have experience, Logan, thank you for being here, really on both sides. So you were a former prosecutor, now you're a criminal defense attorney. We've heard some new developments coming out of the jury room in this case. And so walk us through really the process of what's happening there along with the instructions.
Right. Well, at this point in the deliberations, this has been the point that the jury has been waiting for probably for a long time. They've had to go through weeks of hearing testimony. Prior to that, they had to go through a jury selection. So now at this point in deliberations, their job is to review all the evidence, discuss all that evidence, apply the evidence to the law that has been outlined in the jury charge as read to them by the judge, and then render a true and just verdict based on that application. And in doing so, they can ask to review certain exhibits that have been admitted to evidence. They can ask the judge to replay certain testimony if they have a question as far as what was said during trial. Because as you can imagine, with a 34-count indictment, it would take a lot of work to render a verdict. And I mentioned the jury charge earlier. That is essentially a jury's roadmap to resolving the case, to reaching a verdict. That is where the judge would tell the jurors what the law is on the case, how they can apply the evidence to the law, as well as the various do's and don'ts, such as confidentiality, not taking prior biases into the deliberation room, that sort.
And you mentioned about the judge's orders. That's in addition to wanting to hear some additional testimony or hear testimony over again, they wanted to hear again some of the judge's orders, which means that they must be really processing this entire process for them. So this is not just any trial. This is not just any defendant. We're talking about a former president of the United States. So when you take that, just from your experience, knowing what happens, I guess after the fact in a jury room. How do you think that is a factor in their ability to deliberate this case?
I would imagine it'd be very difficult. It's only human nature to have an opinion about an individual that may affect the way you judge a certain case. And in the criminal justice system, it's important that every individual, even former President Donald Trump, every individual accused of a crime has a right to a fair trial. And so the hope is that there are certain safeguards in the criminal justice system to assure that an individual receives a fair trial, such as the jury selection process, where jurors would be asked, what is your opinion of the former president? Is it favorable? Is it unfavorable? But most importantly, can you set aside that opinion and not let it impact the way you view the evidence, not let it impact your deliberations? Because as I said before, it's only human nature for us to have those opinions that may affect the way we judge certain situations. And in fact, I know the jurors in the jury charge that I mentioned earlier, they were given a limiting instruction by the judge reminding them that in your deliberations, whatever opinion you may have of the defendant, whether it's favorable or unfavorable, you must set that aside and not let it impact your deliberations. As we know, former President Donald Trump, as polarizing and widely known as he is, that's obviously easier said than done.
Okay, and so we obviously are waiting for a verdict. Where do things go after that?
Well, it all depends on what verdict is rendered.
Yeah.
If it's a not guilty verdict, well, the trial is over. Donald Trump walks free, he's acquitted, and he's protected by double jeopardy from the same criminal charges being brought against him in the future and being prosecuted again. In this type of trial, too, with a 34-count indictment, a lot of testimony, weeks-long trial, you do run the risk of a mistrial being declared. For a felony, you have to have all 12 jurors unanimously agree on the verdict. And so if you have 11 jurors find beyond a reasonable doubt that Donald Trump is guilty, but you have one juror that doesn't believe he's guilty, that's not a unanimous verdict, and in that situation, the judge would have to declare a mistrial. That doesn't mean the case is thrown out, and in fact, the state would then have to kind of reevaluate the case to see if they want to try the case again. But I think what you're asking and what everyone wants to know is what would happen if there's a guilty verdict. If there's a guilty verdict, then the jurors would be relieved of their duty. They're not there to determine punishment. That would be up to the judge. But I would anticipate the judge would then set a sentencing date, and Donald Trump would be open to the full range of punishment, which is anywhere from probation up to 4 years in prison.
So if Donald Trump is found guilty, how does that impact his ability to run for president? And if he is able to run and wins, how does that impact his ability to be the president?
Right. Well, if he's found guilty, and from everything I've read, if he's found guilty, there will be a very lengthy appellate process. And the appellate process, it doesn't take a few months to complete. It often takes months to years to complete, and with the general election coming up, it's likely that it won't be completed until after the election. And say hypothetically, say he's found guilty, sentenced to serve jail time, it's likely that he would remain free while that appellate process took place. But to answer your question directly as far as how it would affect his ability to campaign or to even serve as president if he's elected, in short, it wouldn't affect him in the sense that he would still be able to run for president. The U.S. Constitution has certain requirements on what it takes, or if you're qualified to serve as president, such as you have to be at least 35 years old, you have to be born in the U.S. There is not a requirement that you have to have a free and clear criminal history. So theoretically speaking, you could be a convicted felon and still run and serve as president of the U.S.
Okay, Logan Campbell, thank you so much for your insight this afternoon.
All right, thank you all very much
Appreciate
for having me.